Thank you, Mr. Chairman. Judge Barrett, your family, welcome. We're at a critical moment in our nation's history, in the throes of a devastating pandemic, with over 216,000 Americans dead and over 7.7 million infected with this virus. Each day, we are reminded of how this invisible virus has changed our lives and changed America. And there is no end in sight. We face an economy in crisis with millions of jobs lost and crushing challenges facing workers, businesses, families all across America. And we're in the middle of an election season. Millions of Americans have already cast their votes. And this may be one of the most consequential elections in our nation's history, because for the first time in the history of the United States, an incumbent president refuses to commit to a peaceful transition of power if he loses the election. This president, in his vanity and constitutional recklessness, refuses to commit to accept the will of the American electorate. And of course, we're still in the process of mourning the loss of an historic champion of justice and equality, Ruth Bader Ginsburg. Justice Ginsburg spent her entire life and every ounce of strength and talent she was given in the pursuit of America's highest ideal, equal justice under the law. Her absence is deeply felt. Now, this is the context in which the Senate majority Republicans are defying the traditions of the Senate and rushing forward with President Trump's third nomination to the U.S. Supreme Court. It has been recounted earlier that Justice Ginsburg was approved by the Senate by a 96-3 vote. This icon of liberal thinking, advocate for the ACLU, 96-3 before the United States Senate, and then Anton Scalia, on the opposite polar end of the political spectrum, approved 98-0. Amazing. Can this be the same Senate? It's not. The reason those votes were so overwhelming was because people lived by the rules, they lived by the traditions of the Senate, and they had mutual respect for one another. We know now that this process does not adhere to those guidelines. The haste in this pursuit that before us today is unfair to the Senate and unfair really to the nominee. The nominee before us was announced 16 days ago, the day after Justice Ginsburg lay in state in the United States Capitol. We received the nomination paperwork 13 days ago and have learned since then that some materials are missing. The speed with which Republicans are moving to fill this vacancy stands in sharp contrast to the approach taken by the same Senate Republicans the last time there was a vacancy in an election year in 2016. Behind me is the Mcconnell Rule. On February 13th, 2016, when Justice Scalia passed away, Senator McConnell said, and I quote, "The American people should have a voice in the selection of their Supreme Court justice. Therefore, this vacancy should not be filled until we have a new president." This rock-solid statement of principle was made 269 days before the 2016 election. The Republican members of this committee fell obediently in line behind Senator McConnell's statement of principle. They even sent a letter on February 23rd, 2016, and I quote, "This committee will not hold hearings on any Supreme Court nominee until after our next president is sworn in." The letter noted that, quote, "The election is well underway," that was 269 days before the election, and said the decision was, quote, "born of a necessity to protect the will of the American people." Yet when Justice Ginsburg passed away on September 18th this year, Senator McConnell said that very same night, and I quote, "President Trump's nominee will receive a vote on the floor of the United States Senate." He made this statement a mere 46 days before the election. People had already begun casting votes, and my Republican colleagues marched in front of the cameras, looked down at their shoes, dutifully reversed their positions, and lined up obediently behind their leader again. It gets down to this. Either the American people do get an election year voice regarding a vacancy on the Supreme Court, or they don't. In 2016, Senator McConnell said, "Give them a voice." Now he says, don't give them a voice. It is a shameless, self-serving, venal reversal. Why are Senate Republicans so afraid to give the American people a voice about the future of the Supreme Court? First, they must doubt that Donald Trump will be reelected. Second, they want a 6-3 Supreme Court to carry out a Republican agenda that's really not very popular with the American people. And there are 2 dates on the calendar which explain their timetable, November 3rd and November 10th. We know November 3rd is Election Day. President Trump has made it clear he wants another of his appointees on the Supreme Court before the election because he anticipates court challenges over the vote, especially over mail-in balloting, which he has repeatedly attacked without any substance. President Trump has indicated he'd be perfectly happy to have a close election decided by a 6-3 conservative majority Supreme Court rather than by the votes of the American people. The other date, of course, is November 10th. We know that date well on this committee. That's the date the Supreme Court will hear oral arguments in California versus Texas. This is the case in which the Trump administration is urging the court to strike down the entire Affordable Care Act, including protections for tens of millions of Americans with pre-existing conditions. It's unimaginable that in the midst of a pandemic, the Republicans want to strike down a law that 23 million Americans rely on for their personal health insurance and millions more for the protections given to the writing of future insurance policies. On September 27th, President Trump tweeted he wants to see the Affordable Care Act, quote, terminated in the Supreme Court. Let's be very honest about this. This president has never suffered an unuttered thought. He gives us 25 tweets a day to tell us what's going through that fertile mind. We know what he thinks because he tells us what he thinks. And he made it clear that he wants his Supreme Court and this nominee to join him in eliminating the Affordable Care Act. This is his litmus test. How many times have we heard it? How many times have we heard his criticism of Chief Justice Roberts for failing to strike down Obamacare? When he was running for president, then candidate Trump tweeted, quote, if I win the presidency, my judicial appointments will do the right thing, unlike Bush's appointee John Roberts on Obamacare. Think it would mean if the Republicans wished to strike this down, all the people who would lose their coverage, which we have heard recounted repeatedly this morning and will hear even more. Republicans in Congress have been obsessed with repealing Obamacare for years, but they don't have the votes to do it. They couldn't get it done in the House. They couldn't get it done in the Senate, thanks to 3 brave Republicans, including John McCain. And now they've got to rely on the court to do their work. Judge Barrett, you're on the record. You wrote an article in which you criticized the NFIB versus Sebelius case, where Chief Justice Roberts was the deciding vote upholding the ACA. Now your nomination is moving forward at unprecedented speed. So what's at stake? Let me show you what's at stake here. I want you to meet Kenny Murray from Tinley Park, Illinois, and his family. Last year, I had a privilege of meeting the family in my Washington office. Here's a picture of Sue, Ken, their daughter Maddie, and their son Kenny. Sue and Kenny Murray told me that their son Kenny was diagnosed in utero with multiple complex congenital heart defects. Before his first birthday, Kennedy had 2 open heart surgeries at Advocate Children's Hospital outside of Chicago. He had surgery for the 3rd time at 14 months of age. 4 months in his young life, he was staying in the pediatric ICU, and his health bills had reached $1 million. When Kenny was born in November 2013, his dad's health insurance through his employer had a lifetime maximum cap of $1 million. Thankfully, the Affordable Care Act banned insurance companies from imposing these annual lifetime limits, including on employer-sponsored health insurance. That ban went into place in January 2014, 6 days before Kenny's first surgery. If it weren't for the ACA, Sue and Ken would have hit the lifetime limit for Kenny in just 4 months. They told me they would have gone bankrupt. Thanks to the Affordable Care Act, Kenny was able to get the care he needed. This last picture I want to show you, well, here it is. Wouldn't you want him on your team? I sure would. When she gave permission for me to share Kenny's story today, his mom, Sue, said, quote, Kenny is a real person whose life depends on the Affordable Care Act. Judge Barrett, your nomination for a lifetime appointment to the highest court in the land comes before us under a cloud. You have been nominated by a president who shows contempt for the Constitution, but does not hesitate to tell his loyal followers that you are being sent to the bench to do his political chores, abolish the ACA, rule in his favor on any election contest, and even more. You cannot feel good about a president cheapening this historic moment. The future of the Affordable Care Act and so many other issues hang in the balance. Voting rights, civil rights, the right to privacy and choice, environmental protection, gun safety laws, marriage equality, dreamers, work protection. These are the stakes. If we wait just a few more days, we'll know what the American people have to say.